Good morning. Good morning. I'd like to join Jeffrey Rosen in welcoming you to this program. I am Jeremy Fogel. I'm the director of the Federal Judicial Center. And this is the second year that we've done a collaborative program with the National Constitution Center. And it's really a highlight of our academic year. The NCC does such great work in public education, and I think we as federal judges are hungry for the kind of historical perspective that we get from these collaborations. Last year we did a seminar on the legacy of James Madison, and this year we're doing the seminar on the Reconstruction Amendments. But I want to thank the NCC for their work with us, and we're very grateful. We're going to pick up where the last panel left off and talk about what happened after the framing of the Reconstruction Amendments and take us up to the present time. And then we'll follow that up with a third panel with a couple of federal judges talking about the current resonance of the Reconstruction Amendments to them in their work. So with me for this panel are two very accomplished speakers in this area. To my far left is David Kennedy, who's a professor of history at Stanford University and Pulitzer Prize winner. He's written several very well-received and popular books about American history. So he's going to talk about this period. And next to me is Heather McDonald from the Manhattan Institute. She's a fellow there. And she's a social commentator, investigative journalist, trained as a lawyer, who's focused her attention on the modern effects of racial discrimination and prejudice in our past and where they have left us today, and what kinds of social policy choices we ought to be making with regard to that. So I want to start with Professor Kennedy. And just ask you to speculate, if you would, if the people who framed the Reconstruction Amendments were here, what would they regard as their greatest successes and their greatest disappointments?
Well, boy, that's not an in-the-weeds question.
No. No, we've had enough weeds. We're going to stay out of the weeds here.
Well, I'll try to get to that, but,
Yeah, okay.
but before I address that question directly, if you'll permit me, I'd like to revisit something that was touched on in the last session, but I thought was insufficiently developed, and that's the way the persistent, stubborn, structural issue of federalism underlies all of this discussion. And it actually has very specific historical roots, not just in Reconstruction, but in the Civil War itself. Because it was Lincoln's theory that the seceding states had never left the Union. But at the end of the war, there were various opinions about how to regard the surrendered Confederate states. People like Charles Sumner and Thaddeus Stevens regarded them as conquered provinces who had, by their secession, lost all their privileges and rights in the American Union, and therefore could be reconstructed from the bottom up. Others regarded them as disorganized states. They still retained the rights and privileges of statehood, but they were in a disorganized state. Others thought that maybe they had reverted to something approaching territorial status, so they were wards of the federal government, and the federal government had the right to rearrange their political life and structures and institutions as it would a territory. So that debate about exactly what was the status of the Confederate states and how they were to re-enter the Union raised these vexed, deep, troubling questions of constitutional interpretation about what's the nature, the relation of the states to the federal government. So this plays out, it seems to me, throughout all the episode of drafting the 13th, 14th, and 15th Amendments and all the subsequent history. And my summary view of it is that on close examination of the drafting process and the judicial interpretation of the big amendments, what's striking is how there was a struggle to defer to a traditional idea of the states as the constituent elements of the Union and to give them as much leeway and scope as possible for their own decision-making when they re-entered the Union. Subject to very specific conditions of approving the amendments before, especially the 14th Amendment, before 13th and 14th before readmission. But the pattern of deference to the states, it seems to me, is obvious in the drafting process in Reconstruction and becomes ever more evident as the 19th century goes on. So to go back to your original question, it seems to me that in some balanced and summary way, that the drafters of the amendments would have been, on the one hand, impressed with, and in a formal sense, impressed with how the judicial interpretation of the amendments for the rest of the 19th century, anyway, continued the tradition of deference to states' rights, but in a less formal way, probably quite dismayed that that deference meant that some of the higher political objectives of the amendments, which was to confer full citizenship rights on emancipated black men in any case, was frustrated.
So the sort of a way of restating that is that the amendments really were not a fundamental change in the basic federal structure of the country. At least they weren't intended to be. But what the framers were hoping for was within the same federal structure that the emancipated slaves, at least the men, would have certain legal rights that they didn't have as slaves. So the success is you preserve the federalism, and the failure was that the rights didn't get delivered.
Well, that's right.
Yeah,
I think that's a pretty good summary statement of what happens.
Yeah, go ahead.
And in fact, the shedding of what I'll call procured by the results of the war and Reconstruction Amendments, it progresses further and further. You get to cases like Plessy and Williams in the 1890s, and it's clear not only the federal judiciary and the federal government, but the nation as a whole had simply given up on the project of trying to truly integrate black citizens into the general social fabric.
So this raises a question which we'll probably come back to with the judges panel as well. So to what extent was the judiciary the cause of that, and to what extent was the judiciary's decision-making an effect of that? We can start with Slaughterhouse, but then there's a whole other series of cases, including some of the ones you mentioned.
Well, pretty hard to tease those apart,
Right,
I think, in any fair judgment. And probably will not fall receptively on the judge's ears here, but I do think that there's some truth to the old maxim that the courts generally just reflect macro level some degree of public opinion. So that the courts as change agents, I think we should be cautious about investing too heavily in that notion. So I would lay my emphasis on the failure of the national commitment to the freedmen as the most dispositive factor here, and the courts mirrored and reflected that general social attitude.
So they weren't under any social pressure to construe these amendments differently than they did.
Of course, there was some social pressure.
Yeah,
there were, the abolitionists didn't go out of business entirely after the 13th Amendment. So there were still voices supporting black rights. And of course, there were black people asserting these rights as well. The sorry fact is that for all kinds of reasons, emancipated black Americans had great difficulty organizing with sufficient political effect to really press their case. That didn't really happen until the next century, until the 20th century, when you get an organized civil rights movement.
So I know in some of the reading that I did to get prepared for this program, that one of the things that really impressed me was that other than a few radical abolitionists, there was, and I think Sumner and Stevens were mentioned, that there wasn't a big push for social equality, that in fact the rights that even the people who were pushing for the legal rights for emancipated slaves were not big believers in social equality. In fact, social equality was a very out-of-the-box type of position back then.
Well, again, even Lincoln,
Yeah.
even Lincoln is on the record of stopping short of full-throatedly advocating full social rights. But full civil rights, political rights, that's a different story. But there was something else touched on in the last session that maybe it's worth revisiting just briefly, because there was another constituency group in American society which in some ways provided, I don't know how articulate this was at the time or how self-consciously this was done, but it certainly provided at least some kind of a touchstone for stopping short of full civil rights as the program for emancipated black Americans. That was women. Women didn't have the right to vote. In fact, it was a point of contention between feminists and the drafters of the 15th Amendment that the word sex it was advocated that be in there, but it was not. And women enjoyed some measure of social membership and civil rights, but not the ultimate privilege of the suffrage. So there was a kind of model for the idea that emancipated blacks might be granted partial citizenship rights, more or less on the model of women.
Mm-hmm. And so that, in some sense, that tension made it more difficult to get over.
Yes.
For either.
Yeah.
Mm-hmm. So one other factor that I seem to recall from the history is that there was a terrible economic downturn in 1873, and it lasted a really long time. Do you think that was a critical factor as well, that part of the abandonment of the goals of these amendments was simply a result of hard times?
Yeah, I think it played some role. It was 1873 to 77, and it was widely thought to be the worst economic downturn in American history up to that time. Where we were about to see some bigger ones in the 1890s and, of course, the 1930s. But yeah, I think that plays some role in diverting national attention elsewhere. But I should tell you, I first studied this matter many years ago, graduate school. My great mentor was C. Van Woodward, who was a great historian of segregation and the New South. His book, The Strange Career of Jim Crow, Martin Luther King Jr. called it the Bible of the Civil Rights Movement. It was a history of how segregation actually got fastened on the South as an institutional and judicially sanctioned business. And he never stopped emphasizing that the failure of the promises of Reconstruction, if the promise of Reconstruction in the Civil War was full citizenship for emancipated blacks, he never stopped emphasizing that the principal responsibility for that failure lay in the failure of the elites in American society to really step up to their declared values and make things happen.
So that leads right into, I think, a follow-up to the point you made earlier, that you think that the decisions of the courts immediately after the amendments were adopted to a large extent reflected what was going on in society rather than strong philosophical views on the part of the judges. So once this all happens, and you get Slaughterhouse, and you get Cruikshank, and you get the cases that really make, to some extent, make the Reconstruction Amendments a dead letter for a long time. How do you explain the court's inaction to the extent that there was inaction? And I think the last panel mentioned that there were some examples of successful prosecutions, particularly in the voting rights area. But how do you see that?
I'd say two things. One, just to repeat what I said earlier, it seems to me that the pattern of deference to state authority, it seems to me, is quite conspicuous in the moment of drafting the amendments itself. So it's hardly surprising that element gets judicially ratified as you go forward, and a series of decisions that give the states a lot of freedom of action to do some things that today we would regard as pretty noxious. So that's one. Secondly, to use a word that's very current in the county where I live, Santa Clara County, California, the bleeding heart of Silicon Valley, you'd look long and hard for a Supreme Court decision or a court decision in this period that is disruptive of what are more or less settled items of value and opinion out there in the citizenry at large. Unlike, let's say, the Brown decision, which is truly disruptive. It really rubs the nation's nose in the fact that it has to live up to its professed values.
So we'll get to Brown in a second, but before we get to Brown, we have Plessy. So would Plessy sort of be the embodiment of what you just said, that nobody wanted to be disruptive, it was a segregated society, that court did not want to be the one to say otherwise? Yeah,
and again, to use a phrase that's been batted around here already this morning, the legal fiction of equality was, there was a gesture honoring that in the decision, separate but equal. What if that formulation had just been the other way around? Equal though separate. It probably would have been even more strongly fictionalized. No objective observer by the 1890s could really, with a straight face, assert that separate facilities were equal. In fact, that's the Brown decision says separate is inherently unequal. an idea that we fairly naturally affirm today. So yeah, I think that the Plessy decision simply ratified what was by that time a very deeply rooted attitude, outlook in the society at large.
So irrespective of what was intended or not intended, and almost notwithstanding the decisions that preceded it, the court would say, are you ready to bite the bullet on social equality here? And the answer was no.
That's right.
Yeah. So I want to get to Brown, but before I get to Brown, I want to just sidetrack a little bit, and this is as close as I'm planning to get to the weeds. The Slaughterhouse case basically made the Privileges and Immunities Clause a very weak, if not non-existent, source of rights. So what evolved instead was this substantive due process doctrine. It kind of came out of nowhere, and it showed up in the Lochner case in particular. But we're still living with it, as recently as the last term of the Supreme Court. So to what do you attribute that? Just as a historian looking at the way the law has evolved, how did that come about, and why?
Well, as you rightly say, and again, this gets a little weedy for me, but I would defer to people who are better case law historians about this than I am. But the Lochner case is the one that truly makes the substantive due process doctrine the regnant doctrine. In fact, the next 30 years are known as the era of the Lochner court. So how did that happen? Well, not least of all, thanks to the persistent legal argumentation of Justice Field, who first formulates the idea and persistently uses it in dissent and eventually convinces a majority of his colleagues that this is a proper way to do business. Another way to think about it is that the substantive due process doctrine, as it gets applied, actually serves the purpose of fueling the industrial development of the United States in the late 19th century, the moment of greatest, most rapid industrialization. So you could say, I'm kind of going out on a limb here putting it this way, that the court served the purpose of protecting the development of American capitalism at a moment of its critical formation, when it really was trying to transform the whole economic basis of the country. And much as we might not like substantive due process now, looking backward, it did have that protective function and probably, arguably, contributed to the growth of, it catalyzed the industrialization process.
So, I mean, talking with some people before the program, saying it's kind of a workaround. If you'd had privileges and immunities, you could have just used that, but you didn't. And meanwhile, the economy is doing what the economy is doing, and you need some way to make that happen.
Yeah.
So that's where we got substantive due process from.
Yeah. So again, I'm speaking in great generalities here, but to the extent that there's anything to this at all, you might say that in that dimension, the courts also reflected some kind of majority public opinion that it was in the national interest to energize this industrial revolution as rapidly and as fully and robustly as possible.
Okay. So this gets us to Brown. So is the best way to look at Brown simply that the world had changed?
Well, as an historian, and not an historian of the court particularly, but as an historian of more general matters, I think that is a homely but a proper way to summarize things. That we, as a society, came to a different outlook about the meaning of equality and the practical effects of the segregation regime that had been in place. Again, I go back to my mentor, Van Woodward, who in his memoir said something about how future generations will marvel at how their forebears could daily make their way through this anthropological museum of clearly irrational social practices and behaviors, referring to Jim Crow, of course. And I think eventually the irrationality and the nature of Jim Crow and the way it contradicted declared national values just became quite weighty in the national conscience. And again, recollect the core of Martin Luther King Jr.'s appeal was always, we must live up to our declared values. Not that we need to change our values. We've had these professed values for a couple of centuries. Let's make them a reality. And that proved a very, very effective message. There's another historical consideration here, too, that maybe has a place in this discussion. Essentially, the federal government goes out of the business of trying to promote the cause of black citizenship, black equality, black integration from the end of Reconstruction until World War II. And a fairly well-known, but not well-known in this context, I suppose, item is was Franklin Roosevelt's issuance of Executive Order 8802 in 1941, which decreed that there would be fair employment, equal employment access and practices in defense plants in World War II. Another part of what he was asked to do at that time was to guarantee equal access to combat roles for black recruits in the military. He refused that. But he did grant and created an Equal Employment Opportunity Commission to oversee fair treatment of African Americans in defense plants. That, again, to use a word I used a moment ago, helped to catalyze a great migration out of the South, African Americans seeking employment, defense plants in the Northeast, the Upper Midwest, and the West Coast. And in some ways, I think it is one of the foundational pillars of that energized the civil rights movement after the war. So there's a big demographic shift. Yeah. It's fueled by the war. It's aided and abetted by Executive Order 8802. The African American community gets a purchase outside the South where they have more political leverage and can organize on a more effective basis, and we get the modern civil rights movement.
And there were black soldiers who fought in World War II.
Not many,
but some.
Some.
Yeah. And there was case law even prior to Brown that was starting to move in that direction.
Yes. Yeah.
So it's fascinating, and then Brown, of course, opens up a whole era of expansion of rights and of the federal role.
And a redefinition of what constitutes a right.
Yeah.
The rights revolution also figures into this. It's not only that the core right of full citizenship and right to vote and equal access to all facilities is now made a reality, but then we start to, well, I was going to say invent. That's not the word I want. We start to identify other rights.
Right. Certain rights suddenly are recognized judicially that weren't before. One of the things that always interested me, and then I want to turn to Ms. McDonald, but the learned hand wrote to Justice Frankfurter that he actually thought that Brown was wrongly decided, but that he couldn't, if he'd been on the Supreme Court, he probably would have decided it the same way. It's just the tension between following precedent and
and the right thing to do.
The right thing to do as what the right thing to do emerges over time, and that's something we as judges struggle with constantly.
Sure. But the important point here, I think, is implicit in what you and I have been saying to each other, but let's just underline it, is that values and society's identification of values and the strength with which they hold them and assert them all that changes over time. And the law has to be sensitive to that, it seems to me.
So let me turn to Heather McDonald, and when we were talking a while ago in preparation for this, we were saying that there really isn't much issue that the period between the adoption of these amendments and certainly the beginning of the modern civil rights movement after World War II, that was a pretty sorry time in terms of equality of treatment for African Americans and other minorities. But then we've been in this period for the last 70 years or so of pretty dramatic social change. And you've been critical of a number of the policy responses that we've as undertaken as a society in light of that history. In other words, that the history happened, the history was very tragic and very hard on lots of people, but the question is, what do you do about it? What's the way forward? Do you want to say something about that as a way of starting the second part of this?
Sure, thank you, Judge Vogel.
Sure.
Well, first of all, if there's any meaning to American exceptionalism, it is this extraordinary conjunction of the most beautiful and arcane commitment to law and text and judicial legal interpretation that gets you in the weeds, superimposed on top of some of the most brutal and ugly sentiments that human beings can possess. And this American history of a constant rereading of foundational documents with the pressures of either trying to maintain a oppressive hierarchy or break that up is an extraordinary fact. And I'm not sure any other countries have that odd juxtaposition of some of the highest capacities of human reason to engage with language and these arcane hermeneutical questions of original intent, whether there can be such a thing with a document that has been drafted by so many participants, and that interaction with the desire to enslave and then continue a de facto system of enslavement. And I would be less likely to sort of relegate the judiciary to a simply imprimatur upon developing social change, because I think that obviously the discourse that they engaged in with such seriousness and care is part of Americans' history and constitutional identity. And one sort of falls on one's knees before the enormity of American history and the constant efforts to undermine the promise of our founding ideals. And so one needs to be very careful in declaring a point where the issues are no longer ones that can be decided by judicial interpretation or even indeed governmental power, and to declare ourselves free enough that we can talk about other issues that may be preventing the promise of equality. But I do think that as essential as the long process of judicial hermeneutics have been to freeing us from the evil and the hypocrisy of this history, that now some efforts to try and make sure that we have equality of results are not working well. And I would point out, for one example, racial preferences, which is obviously a continuing discussion at a constitutional level, and one that is addressed with an extremely arcane jurisprudence of standards of review, discussions about what strict scrutiny should mean, and discussions as well about problems of reverse discrimination and whether a preferential policy goes beyond the promise of equal treatment under the laws. My recent interest is cutting through what I think has become perhaps a stale and stalemated discussion about that, and look simply at the practical effects of racial preferences. And I've been very persuaded by a doctrine that is, or not a doctrine, it's not a legal doctrine, it's really an empirical theory that has come out of the UCLA Law School, Richard Sander, looking at the fact that in his observation, racial preferences actually hurt their intended beneficiaries, above all in an academic context, that by catapulting people into academic environments for which they do not share the qualifications of their peers, you're not actually doing them a favor. You're putting a burden on them. For example, if MIT decided that it needed a lot more females in their physics department and reached out and said, okay, Heather McDonald, you're admitted to MIT, I would fail immediately. This would not be something that would assist me in being able to absorb a scientific doctrine. I would be much better off in a state school where the teaching was directed at my capacities, and where I was in a group of people that would have the same background, academic background, and same needs. In the same way, Richard Sander has looked at the academic outcomes, especially in law schools, of students who have been admitted under racial preferences, and has found that those who have been do more poorly on bar passage rates and their GPAs than students who have been admitted under a colorblind standard. So what my interest has been as a journalist is to go out and actually look at how social policies are working in practice and whether they meet their intended goals. And what I often find is that they do not.
You know, something you said at the very beginning not only interests me, but it's one of the reasons why we wanted to have this event. And that is that you say we need to look at things differently, that the debate has become stale or stratified, and it's inevitable that that would happen, right? Because you have 150 years of history where things didn't work out the way people intended them to, and where, despite all of the wonderful things about our country and about our society, this is not our proudest moment. And I think everyone can kind of see that. But then when you actually try to talk about well, what should we be doing, that if what I hear you saying is if what you're proposing does not fit the conventional wisdom, or it doesn't fit into the received wisdom, that your motives are suspect, that the content of what you're saying kind of gets lost in the well, what side are you on? Do you really understand what this experience is about? You know, what it would mean to have grown up in the Jim Crow South or something like that. And I know just in talking to people about it, it's hard, because unless you have the credibility that you feel the experience or you understand something about it, it's very hard to say, you know, actually maybe what we're doing isn't the best thing, that the people who are saying that we should be doing something else haven't lived the discrimination themselves. So what do you think about that? How can we try to bring those threads together?
You're saying that critics can be the attempt to undermine them by saying they do not have the history, or let's be honest, the skin color qualifications to address certain issues. And that is a tough argument to withstand, and one can only argue for the sake of, again, empirical evidence and drawing on our ideal, which is that skin color should not matter to one's rights to participate in a discourse. And I would also say, obviously, there's no monopoly anywhere on any particular point of view. I've written a lot about policing, which is obviously an issue right now, which is in the forefront of national attention. And I think I can fairly say that the discourse on policing today tends to be fairly monolithic in the critical views of the police, that from the president on down, the assumption is that the police really are a problem, and that they carry with them still the prejudice and misuse of power that has characterized so much of American history and so many American institutions. What I have done is go out into the communities where this debate has its origins and find very different voices. People in Harlem or Central Brooklyn who feel safe when the police are there and only when the police are there. And for example, I met a a cancer amputee in the Mount Hope section of the Bronx, Mrs. Sweeper, who said the only time she felt safe to go get her mail in the lobby of her apartment building was when the police were there. She said, "Please, Jesus, send more police." The people in her neighborhood begged to have a police surveillance watchtower on their corner. Again, they said, "We want it back." They'd had it before. They said that was the only peaceful summer we had. They feared not the police, but kids hanging out in their lobbies, smoking marijuana, dealing marijuana, the kids hanging out on corners, fighting, and the police are in a difficult situation because for them to respond to the heartfelt requests for order that they hear again and again in their precinct community meetings will, by definition, generate the sort of racially disproportionate stop and arrest data that can then be used against them in an ACLU or even Justice Department lawsuit. So what I have found is that it's very easy to find people who are across the political spectrum on these very challenging and painful debates that we're having now.
Mm-hmm. And I guess the question for both of you is, how do we change the debate to a more synergistic one? I mean, because we can find people who feel that, as you do, that we're not looking critically enough at the actual results of the policies, and that we're kind of there's a political correctness to the policy approach. There's other people who feel that we still don't get, at least white people don't get. We really don't get racism. We don't understand what life is like, has been like, and thus we're not in any position to really talk about it and what kinds of remedies would be appropriate. So I know we're getting pretty far away from the Reconstruction Amendments, but this is all something that happened because of the way Reconstruction happened. There were promises made, there were promises that were not fulfilled. How do we move forward? And I believe we'd ask this question to both of you.
It's very tough, and I think, again, our history is one of argumentation and debate, and sometimes that breaks down, and we've had violence of the Civil War, we've had the violence of Jim Crow. But I would say, again, and it's easy to invoke facts, and it's easy to, everybody invokes common sense to mean my common sense and my facts. But I would say that let's bring in another alternative. Yes, the history dies very hard, and particularly in policing. The police have been a bulwark of brutality, and that's a history that is hard to move beyond. But I look around the world, America today, and what I see is virtually every, at least elite institution and practically every business that is eager to admit as many blacks as possible, that every university has a system of racial preferences that extends both to admissions and to hiring. Diversity is a constant theme of corporate America and of government. So to me, the problems are much less today about formal or even informal barriers to opportunity, and what we need to look at is the culture that is impeding too many young, especially black males, from taking advantage of the opportunities that are there to them. And so again, I will say that empirically one can show that this astoundingly, and as much as one wants to be careful about declaring ourselves effectively free from the poison of our history, I think on balance, it is time to start speaking as well about self-help and self-discipline and personal responsibility above all else.
Thanks. Professor Kennedy, what are your thoughts about this
Well,
as a historian?
I actually had a thought in anticipation of this discussion that drove me back to a passage in an essay by the great British philosopher and historian of ideas, Isaiah Berlin, and I'll read it to you in just a moment. But I want to go back to, Heather, what you said about racial preferences, affirmative action, a notoriously vexed and difficult, complicated question, emotionally charged, legally complicated. There's all layers of complexity about it. But again, to take us back to where we began in the Reconstruction era, you might say that our generation's confrontation with the vexed issue of affirmative action, racial preferences, is a recapitulation of what sometimes has been called the abolitionists' dilemma in the immediate post-Civil War period, because the abolitionists had been arguing in the first half of the 19th century, and rightly so. I think very few people today would disagree with their argument that slavery was a debasing and a degrading institution that relegated certain people to sub-citizen status, maybe even subhuman status by some definition. And the dilemma was, of course, that once these people, Black Americans, slaves, were emancipated, you had to recognize that they were, in fact, less capable than their fellow white citizens of fully participating in the social life of their society. They were largely uneducated, in many cases illiterate. They had no experience of political participation or even social participation. So what do you do about that? Well, the Reconstruction era generation did quite badly with that. Their one effort at a positive intervention to speed up the process of social integration was the Freedmen's Bureau. But the Freedmen's Bureau only existed for a few years. The Congress refused to authorize it and fund it going forward. So that effort was very short-lived and failed. Affirmative action in our time is a kind of an echo of the philosophy that animated the Freedmen's Bureau. And I think, frankly, we may not have it exactly right either, but I think we ought to give ourselves credit in our generation for taking the issue on and trying to figure out what's a practical solution to the issue of inequality, especially inequality that is rooted in racial difference. So here's the passage from Isaiah Berlin's 4 essays on liberty that, to me, it really is the philosophical rationale behind both the Freedmen's Bureau of the 1860s and the matter of affirmative action today. He says the following: to offer political rights or safeguards against intervention by the state to men who are half naked, illiterate, underfed, and diseased is to mock their condition. What is freedom to those who cannot make use of it? Without adequate conditions for the use of freedom, what is the value of freedom? So I would say that my summary, the way I would summarize that statement is that we often fetishize freedom. In my view, and I think here Isaiah Berlin and I are on the same page, freedom is a necessary but by no means wholly sufficient condition for the full social membership of everybody in this society.
And so you need to look at the things that empower and enable people to take advantage of the freedom
and that can change over time.
Yeah. One of the things that has fascinated me, and we haven't talked about yet, is back, it came up in the earlier panel, that the focus and the founding of these amendments was on property rights. And in reading some histories of the time, that was something that the former slave owners totally got. And so there was a tremendous pushback against the freed slaves owning property. That's what a lot of the black codes were directed at, and then there was terrorism directed at those freed slaves who were able to own property. And you sort of see that still being an issue. There was an article this week about sort of the return of redlining, or the perception that redlining has been practiced by some of the banks. Is that kind of where you're going? I mean, it's things like being able to own a home and being able to have a good education and being able to have a good job, and not to omit what you were saying about self-help and personal responsibility, that it's sort of all of the accoutrements of full citizenship.
Well, again, one has to be humble and be very cautious about saying that a quote like that is meaningful but less so today. But I would say the doctrine of disparate impact, for example, sort of illustrates the fact that courts are hard-pressed to find explicit barriers and affirmative discrimination today, and instead are looking at policies that are neutral on their face but have disparate impact. And why do they have disparate impact? It's because there are unequal qualifications and social capital today. So I would say for me, the biggest problem is what is being conveyed in the home. Are children being taught to read by their parents? Do they have fathers in their home? That, I think, is the greatest barrier we have today, which is the gap in children being raised by both their parents. And there's nothing that is more predictive of future success than whether you come from and of economic strength than whether you come from a single-parent home or a two-parent home. Which isn't to say that there are thousands of heroic single mothers that are doing the best they can and are raising children to participate fully in the American experiment, but statistically it's a much harder thing.
Yeah.
So again, I think redlining may be going on out of sheer look at the return, the likelihood of repaying loans. I do not think banks today are proceeding under racial animus.
That's an interesting, I don't know enough about it to have an opinion. There was some suggestion that where offices were located was somehow affecting people's ability to get loans. But I think more of the point there is to say these are things we need to talk about and examine and think about as objectively as we can and without preconceived notions. I think I found this in my own life and just in talking to people. This is the hardest thing to do, is to actually kind of look at the facts on the ground,
Right.
Without having an idea where you think they're going to come out ahead of time.
And the facts on the ground that I see is if you graduate, let's be honest, if you graduate from high school and you're black and you have a decent GPA, you have every college in the country beating down your doors to get you to enroll. And that is going to continue in law school, in business school, in medical school, and also in many, many corporations today. And so I think our focus has to be on making sure that there are more children that are capable of taking advantage of what is, I think, a remarkable turnaround in the attitude of America's elite institutions towards racial equality and wanting a diverse workforce.
Great. Well, I think we're going to need to leave it there. There's so much to talk about, and we will continue the conversation in our next group. But I want to thank Heather McDonald and David Kennedy for a great conversation. Thank you. Thanks.